much. Okay. Good evening, everyone, and thank you for joining for our fireside chat. Today we have Daphne Benford-Smith, who works on the legal side of Gamedev. So as always, we start with a little intro from the speaker. So Daphne, if you could tell us a little bit about what yourself and what you do.
Yes. So my name is Daphne. I am counsel at Holon Law Partners. And what I do there is um, I do trademarks and copyrights and outside general counsel work for those that are in the video game industry, particularly indie studios. And so what I do is I help them, make sure that their games are protected, make sure that they understand their rights, make sure that they have the right type of documents and contracts in place, so that they can, be able to navigate relationships within the studios and also outside of the studio. And so that's what I'm privileged to do. I do work in other industries, but this is like my what I would consider my baby industry. The one that I'm, most passionate about is with my video game clients and my anime and manga studio clients. And so that those are the industries that I work in, and I love doing what I do.
Okay, I was just like, I should not turn this into a manga panel like I kind of wanted to for a second when you're like, wait, manga and anime as well. What?
Oh
So,
yeah, I do have manga and anime clients as well.
okay. So are there any like particular like I'm so like you were really excited that you got a chance to work with this company or that company?
um, yes, I would say that I was probably um most excited to work with. So one of my clients is Cleo Thomas. And for those who may not know who he is, he was in the movie Holes. He's also pretty big in the gaming industry. So I've done some work with him. I have another client, Studio Maho, and they are doing pretty big stuff on the anime and manga front. Just um, with their animation projects and their manga projects really taking off. Them and Captain Zero, they're part of the same organization. So I've been excited for that. I feel like all of my video game clients are exciting right now. A lot of them are putting their games up on Steam, like they're getting the demos done. And so it's very exciting. I'm also working with Aerial Knights.
What? Neil's not
Yeah,
here. Ah.
yeah. So I have a collaboration with them. I'm very excited to work with Neil. He's phenomenal. And so we're working on a very cool project that could benefit multiple indie video game studios with publishing agreement assistance and stuff like that. So it'll be really cool. That's something that you guys will find out about once it's done. This is still a work in progress, but yeah. So I get to work with him, and I was extremely excited for that. So it's been a lot of exciting opportunities and getting to meet with really cool folks that are in the industries that I service. So it's been cool.
That is cool. It's like, all right, now that you said that, it's like, we gotta get Neil in here at some point. So I'm
No,
curious,
definitely.
what led you specifically into like this sort of like subsection of entertainment law?
Yeah, so it's funny because growing up, I was always playing a video game. To the point where back in the 90s as a kid, they'll say, well, why don't you just read a book, or why don't you do this? And yeah, I would play with dolls and stuff like that, but I was always playing a video game. And so, when I got into law school, I realized that I didn't want to do the typical lawyer, fields of criminal law and family law, even though I did dabble in those a little bit just to, get some bread on the table. But, I knew that I didn't want to do something that was boring. I wanted to, work in an industry that I felt passionate about, that felt fun, with clients that felt fun. And, I didn't want to go into the typical law areas. I know y'all pretty much everybody in every state sees those personal injury billboards. I just didn't want to. I didn't want to be that person.
There's
You
so
know,
many
I
of those
just
in Philadelphia.
yeah. I mean, it's every state. You know that you see them everywhere on the highways and everything, and those people make decent money, but it's just that work didn't excite me. It was very boring. It was very typical, and so I wanted to do something that went against the grain, and that really excited me. And so I'm privileged to work for a firm that shares that vision, because the legal profession can be a little antiquated. A lot of people tend to want to do just the typical stuff. But, I'm at a very forward thinking law firm that's just like, no, we want these video game clients. We want to play their games too. Like, we want to, help them, grow and protect their rights and everything like that. And so, I that's pretty much how I ended up doing it for real, was when I got connected here, because they've allowed me the space to really grow and flourish in those industries. But throughout law school, it was a dream of mine. I would tell people all the time, and I did my dissertation and thesis on, like, loot boxes in video games and stuff like that as well. So it's always been something I wanted to do, and I'm very happy that I get to actually live it and do it now.
Okay, that's actually really cool. That you've been on a mission for this for a while.
Oh yeah, no, it was always in me. Like, it was something that I definitely, I just knew that I wanted to do it, because these are things that, meant a lot to me, as a child, watching anime, reading mangas with my friends, playing video games with my cousins or with my friends, and, everything like that. It was a big part of my life. So it's like, I wanted to be able to incorporate both, because I do have a love and passion for the law. But,
Yeah.
I wanted to make it relevant and fun for me, to where I actually look forward to, doing the work that I do, as opposed to, dreading work every day because I'm doing something dull and unfulfilling, So, yeah.
Yeah, it is very nice that you found a way to like combine these interests that you have, and also you find a way to like, yo, like I love games. What's the way that I can be involved in this process with like the skills and like passions and interests that I have?
Exactly. And that's just, that was just something I knew I wanted to do. And so to see, where it is now, and where it's going with all of the different collaborations and people that I've met, it's very exciting. It's very exciting.
So a question about some of the client, obviously, like keeping this to like not like breaking any confidentiality agreements. But
Sure.
what are some of the like most common sort of like type of clientele? Like, are they really small indies that are just starting? Are they like
Mhm.
smaller companies that are kind of established already?
Yeah, so it's been a mix of both, but I would say majority of it would be the ones that are starting out.
Okay.
And to be fair, I don't necessarily, well, okay, so I feel like I've probably geared things more towards those people, because they're going to need my help the most. Not that I don't want to help people that are established, because obviously I'm working with Aerial Knights, they've been established. I'm
Yeah.
working with people that have been established in some capacity. So, I definitely enjoy working with those companies and individuals as well. But the ones that are starting out, those are the ones that I know for sure are going to need, the bare bones legal work, like the
Yeah.
contracts, maybe they need to establish their LLC, or they just need advising on how to do that. They need to start thinking about trademarks and copyrights, and just some of the early onset, issues that we see, when people are developing their video game idea, or trying to establish a studio. So I like to work with people at the onset of that, and you know talk them through, just the things that they need to be thinking about early on, so that way, they can establish themselves properly and really grow, and take on the world with their game, right? But, sometimes a lot of people just jump into the game part and they don't think about the legal stuff until something happens. And so I like to get that early on.
Right. It's not a problem until it's a problem, and then all of a sudden, well, what do I do?
Exactly.
Is it often sort of like the same sort of issues? Like, there's sort of like, let's say, common things that you're usually helping people with?
Non-disclosures.
Oh, okay. Yeah, sorry.
Yeah.
I was like, I'm not sure how close this is. Like, maybe, yeah, this might get shot down question. Okay, makes sense.
Yeah, no. Non-disclosures are big.
Okay.
And understandably so, because if you haven't published the game yet and you're still working on it, and you probably just have like a small team of people, and there's nothing that's really completely binding this person to your game or to your company, and they're contributing a lot of work or information, what have you, and then they decide, you know what, I don't want to do this anymore, I want to go work over here at a different studio B, and I'm going to leave studio A. Well, then that causes an issue, right? So more often than not, people will reach out to me initially asking about, drafting a non-disclosure agreement. And that's when I can also give them the spill on, hey, while we're at it, these are all of the other things that you need to consider getting or looking into. So I would say non-disclosure is a big ticket item right now.
Gotcha. Are there any things? Okay, I was gonna say is that like since you kind of mentioned, are there some things that you commonly see that like developers have not considered at all, and it's like a common thing? You're like, you could really look into this, like maybe before you put that game on the market.
I would say the intellectual property. So intellectual property, is an umbrella term for copyright, trademark, and patent. Now, I do not do patents. That is a very specialized skill. You have to have a particular license to do it. And so there are patent attorneys, and that's primarily what they do. But I do trademark and copyright work. And so a lot of times people may have the misconception that just simply getting an LLC and maybe having some sort of contractual agreement will protect their intellectual property. And that's not necessarily the case, right? If you look at AAA studios, one of the biggest ways that they distinguish themselves from indie studios is by having, an extensive trademark or copyright portfolio where they're very quick to protect their video game series name, which would be a trademark, or they're very quick to get their game code and maybe some illustrations copyrighted because that's artistic expression, in a form of visual audio work. So those are the things I would say people don't consider. Another thing would also be just like, publishing agreements, which again, I'm working on that with Aerial Knights. We're doing a project that involves publishing agreements. And I think that the biggest issue is that people aren't understanding the terms, and so they may enter into publishing agreements that may not serve them, because they're eager to get this game on the market and maybe get like a little bit of funding, maybe a little bit of marketing from someone who, may have um, the bandwidth and the audience to assist with that. But it's very important to understand, those contracts, and have an attorney review before signing it, and not just accepting any offer without negotiating those terms. So that's definitely, another big one, and just also, just contracts that establish relationships, or just documents that establish relationships. Like, is this an independent contractor, or are they considered your employee? Or did you have them sign a work for hire agreement where it's like they understand that they don't have copyright rights in what they're working on, that the studio owns it,
Right.
type of thing. So those are just some, pretty common ones I see that people, may not consider at the onset, but once I walk them through it, then we try to get that taken care of as soon as we can.
Are there any interesting, like, uncommon ones? That, like, someone came to you and you're like, well, that's an interesting problem.
I haven't seen any yet that were just uncommon. Um, I'm really trying to think. No, I feel like everything that I've seen is pretty standard. At least for like the video game clients, it's been pretty standard. Nothing too crazy yet. I'm gonna knock on wood. But I mean, if it happens, then then I'll probably write a blog on it or something. But no, everything has been pretty typical. I mean, I also have clients that are, trying to publish, mobile video games and stuff like that. And so, those problems may be a little different because you're dealing with Apple and Android, store and trying to get that uploaded. But I wouldn't say that it's unique enough to really talk about.
Interesting. Yeah, that's just kind of cool. That, like, if you asked me to guess, I would not have guessed that, like, everything's like, nah, everyone's just kind of like got the same problems. They're just kind of going through the motions again.
Yeah. Yeah, no, everyone's pretty much, at least at the moment,
Yeah.
everyone is pretty much, kind of in the same boat. I've had so many, well, I feel like most of my clients, like, questions or concerns have revolved around non-disclosure agreements.
Right.
Like, or just like making sure that they have the copyright protection and stuff like that, or just making sure that the contracts are well written, so that they don't get screwed by someone who's working with them and and who decides to leave. So I feel like everybody's kind of doing the same type of thing, or it's a lot of the same type of issues that are coming up.
Okay. Is there anything that you think is helpful for, like, people to prepare before they go to legal counsel? Like, it would make that process smoother if you say, like, go look into this on your own before you come in, or, like, just have this information prepared and, like,
Yeah, I would say one thing is probably to know what you want to name your studio. I know that that sounds very like, wow, of course you should know that, but some people don't. They may have like the game idea, they may have the game that they've just been working on, but they haven't even thought about, oh, should I do a studio, or that sort of thing. Um and the reason being is because you would want to get, that as an LLC. Then once you get that as an LLC, you can file the trademark application. The LLC will own the trademark, but then you can also get the name of the studio trademarked for, whatever you're doing, like, which is of course creating video games. And, some studios want to do other things like merch, kind of like Nintendo, right? Nintendo has several trademarks. They have trademarks for not only, creating and selling video games, they have trademarks for, various types of clothing and merchandise. So, these are things that, folks have to think about. Like, it goes beyond the game. You have to be forward thinking, right? And so you ideally would want to, have some sort of studio name, maybe have an LLC, which, I mean, I tell people you can pay me to do an LLC, but you could easily just do it yourself if you go through your Secretary of State's website. They're pretty straightforward unless you just have a lot of board members and stuff, which that can be more complicated, but most indie studios don't. So I would say having the name, having an LLC, and just overall having an idea of what you want to do with this game, and with the studio. Like, because I mean, is this going to be a series? That's important because you have to know if it's a series to get it trademarked. What type of franchise are you making, right? Who is working on this project with you, and what type of relationships. are you like a subsidiary of another, studio? These are things that, you would have to kind of know. And then that way, once you bring that information to me, I kind of know, okay, what direction we're going in. And then we can start having those forward thinking conversations of, okay, who's going to own the trademark and the copyright? What contracts are we going to need at the onset? And then, we can supplement and do other contracts later, but which ones do we need right now? And then, kind of go from there.
Question: would the trademark like change between it being just like a one-off game versus being a series?
Yeah. So here's the thing and this is the same with novels as well. So with books and with video games, to get it trademarked, it has to be a series. So you would have to have, prime example. Pokemon is considered a series. There's several Pokemon games now, right? You have you have the green, which I know a lot of people don't know about green, but you have green, yellow, blue, um, red, and gold. So like you have all these things. So when you go and look at the copyright, or not the copyright, the trademarks, you'll see Pokemon Gold, Pokemon Silver, Pokemon Heart Gold, Pokemon Soul Silver, like, and they'll just keep going, going, going. If it's just a one-time game, then the game itself wouldn't necessarily be something that you would trademark. So, just to give an example, because I don't know if this would count. Well, no, it would count as just a one-off. Stardew Valley. Um, Stardew Valley is just going to remain what it is, a one off. Then what Concerned Ape would probably want to do is, get trademarks for like merchandise that they sell for the game, or other like various items that involve the game. But for the actual game itself, they wouldn't necessarily be able to have that trademark because it's not a series; it's just one game. And the rationale behind it, I know this may not make a whole lot of sense, but I'm going to explain what the law is. The rationale is that, they don't want, so the thing with trademarks is that they don't want anyone to hog the marketplace. They don't want anyone to monopolize on a name. So, there can be several books with the name Awakening, but they're completely different books, right?
Yeah.
And they have different authors and different characters and stuff like that. Now there could be a copyright issue where someone completely copies somebody, but as far as the title, that no one can own just that name unless, there's a series with it that would differentiate it between other books with that same title. um
Okay.
you don't want to hog that name, and then someone else tries to, make a game and their game is different, and it's a one-off, and then you're like, hey, well, I own that name. No. And it's completely different from yours. But um that's the thing with trademarks. It's about pinpointing the source of a good or service in commerce. So when we see Pokemon, we know where that comes from. When I see Pokemon Soul Silver, oh, the Pokemon Company. Oh, Nintendo. You think of these things, right? And so that's the rationale behind it. We don't want anyone to just completely, hog this particular name unless they're making a series that would, you know, make it unique and point to them as the source of this game. Right. So that's why a lot of these big franchises, they'll have multiple games. So that way they can get those trademark protections.
Interesting. Actually, I'm going to jump to a question from Tony because I think it's really good that it came up. So, could you explain the difference between a trademark and a copyright?
Yes, yes. So that was actually, I was gonna do that next, because I was like, I started explaining what a trademark was. So I was like, I probably should. So okay, with copyrights, I'm gonna make it very simple. Copyrights are for artistic expression. So think song, movie, motion picture, like animated series. That's what copyrights are protecting. Is protecting the artistic expression. So no one out there can, steal, if you created a character, I'm gonna just use Deadpool because for some reason I've been thinking about Deadpool and Wolverine.
For some reason.
For some reason. The character design for Deadpool is what would be copyrighted, right? Like the way that he's, if it was like an animated thing, the way that he's drawn, or even Spider-Man, that's a better example. The way that Spider-Man is drawn, like with the red, the blue, the way that his eyes look in the suit, the lines, that would all, like, that whole artistic work, the art would be copyrighted, because what we care about for copyright is the artistic expression and not an idea. It has to be pen to paper, or on screen, or somewhere where we can perceive it. But that's what copyright protects. It protects art. Okay, it protects various forms of art or artistic expression. Trademarks don't care about that. With trademarks, you are not caring necessarily about the content as much as you care about where it comes from. My perfect example of this is, if anyone has seen Coming to America, McDonald's versus McDowell's. That was a trademark issue because the name, is, when you see McDowell's and when you saw the golden arcs, he's like, he would say that people would look at that and think that it's McDonald's. That's confusing the origin of the logo or the name. So with trademarks, you're protecting the logo, the name. Some people get a color trademark or a sound trademark. Those are pretty rare. Like Barbie pink is a color that's trademarked, or Tiffany blue, because when you see those colors,
What?
yeah,
Barbie
yeah.
pink?
Barbie pink is trademarked. It's been trademarked for a long time, and that's because when you see that particular color pink, you're thinking of the brand. When you see that blue box, you expect that to be a Tiffany ring or Tiffany necklace, or something that comes from that particular company or brand. When you see a swoosh, you're going to think, oh, that's Nike. And so if it says another name, you're going to be like, that's not where that comes from. Because with trademarks, you're caring about the origin or source of a good or service. So, if someone tried to do, which is kind of funny considering, what's been happening in the past couple of years, but if someone tried to file a trademark for Pokemon, you know,
Moose.
Pokey Moose, then it's going to be rejected, because you're causing confusion as to the source of the good, or so, especially if they're doing it in the same type of class of goods and services. So yeah, that's what trademarks protect. It's protecting the source of something. So when people in the marketplace, like consumers specifically, see a certain logo, see a certain name, then they know, oh, I know to associate that with this company or with this brand. So that's the difference. Copyrights are not, geared towards, you know, uh, consumerism in that regard. It's just literally about the artistic expression, um, of a work. So that's the difference. I hope that makes sense. Yeah, Pokemon. See,
I was just like,
it's that Pokemon. Power World. So I actually want to bring that up since Jamal said Power World. Um, I did write a blog about this, and here's the thing. That's pretty tricky when it comes to copyright law and video games. Honestly, copyright law in a lot of areas, but for purposes of our conversation with video games, is that you, even though you can copyright like your code, you can copyright your illustrations. you cannot copyright ideas. You also cannot copyright style. So the issue with Power World, that, and honestly, I think that there's even, there's arguments that can be made, but the issue is that there is a case that's been, in existence since, I want to say this was like 91, somewhere between 91 and 95. And I did write about this. I might have to drop a link and or share it with you guys later. But the problem is that there is a case that's still, pretty much in control, that says that, just because someone creates a game that has characters that are, that may be in the same artistic style, doesn't mean that it's copyright infringement. Now, I don't know if I completely agree, given a lot of the implications with the Power World situation, where, there were allegations of AI use in creating some of these characters, and, I included side by side in the blog, and I'm just like, you can't tell me that this is not just a knockoff of Pokemon personally. But technically speaking, if the codes are different, and, you can, use an art style and, differentiate it, then that could still be considered independent, artistic expression, or what they would call under the law original work of authorship. And that's important for copyright, is that you have to be the author, or it had to be, something that's original and not something that's copied. And so I have a lot of feelings about that situation. Oh, okay, you found it. Okay. So yeah, I'm not convinced personally. I still think that Pokemon could have a case. I know last I checked that they were, kind of investigating that, but I did say, even in that article, that that case could prove to be problematic, because nothing has overturned that decision just yet. So I really want it to be litigated. I mean, they can still litigate it, Jesse. They can still litigate the case, and, that could result in new precedent that, can help, especially with the type of technology that's out now. A lot of the copyright cases in video game law, I mean, they're 30 plus years old. I mean, some of them even 40 years old or more. So a lot of these problems need to be readdressed with, especially with how technology is now. But I still personally think that Pokemon has a case. I just think that particular case that I cited could prove to be a problem. Yeah, 40 years old, Tony. It's a lot of
I thought I was the only thing that'd been around that long in game dev.
Yeah, no, a lot of these cases go back to like the 70s. There's even one case I believe that was in like 1968. I've read a lot of those cases, and it's crazy. So so I can't make Sonic the Hedgehog. Yeah, that could probably be an issue. More so with trademark.
Like being sued, but
That would be more of a trademark issue for sure. I mean, even if they can't get you on copyright, they could get you on trademark. For sure, because that's McDonald's versus McDowell's.
Yeah.
100%.
I was like, or if it's like, we don't think we've got a case, but we got more money for lawyers than you, so
Yeah.
I was like, we'll just do this the old-fashioned way of just drag you into court and bleed you out.
Yeah, and that's the thing that a lot of those studios will do. But, I don't know what Power World's money situation is, especially with how much the game took off. But I mean, as you can even see from the pictures, I mean, gosh, like the the creatures are so similar. I mean, they're just very similar. So
Yeah, this is actually not something I'd ever actually considered from like a legal standpoint of just like how similar does this get before it's like I think you might actually have a case here.
yeah, especially since it's not necessarily a parody. But yeah, like I said, art style, you can't monopolize art style, so that's the problem. And that was in the Street Fighter 2 case. Yeah, that was what it's called. And so, yeah, but again, this was in 1994. I feel like this is something that's going to have to be readdressed, because it's just a little too identical, in my opinion. Because I mean, art style is one thing. These look like carbon copies of one another, in my opinion. So,
Just out of curiosity, I mean, this is like I'm wondering how much of that like old litigation had to do with like the limited like visual assets we had back then, whereas now,
yeah, yeah,
whereas
it was
now is that like
definitely. I'm sorry.
no, whereas now is that like no, there's so much more we can do with technology. If you have things looking this similar, it's like no, this was on purpose. You tried to look like these characters.
Yeah, no, that's the thing. I'm like, that looks way too close for comfort, but yeah, a lot of it, like I said, it's just very antiquated. Limited technology back then. I mean, there's a literal case about that brick game that used to be on old mobile phones back in the day. Or computers. It was also on computers. So I mean, like a lot of the jargon that's used in these cases come from those types of case precedent where it's like we're talking about a game that only involved a stick and a ball or something. Like it's not the intricate details that we see today, that's very lively, that looks very real, and the realism that we can achieve now. And even with the use of AI, which of course AI has always been used in video games, especially with NPCs and stuff like that. But the way that it's being used now as a tool to create characters and stuff like that, these are things that just have to be addressed. And we can't rely on law that was created, around arcade games, like actual, like just arcades, or video games that had three colors and were on a brick-sized computer. It's just one of those things that we have to, readdress, or just go back to the drawing board and really create something that makes sense in this day and time.
Hold on just 1 second. There we go. No, but that's really interesting. It's really cool to think about like how this precedent was set based on like what existed at the time and how it's
Mm-hmm.
like not really relevant like in today's world.
Yeah, it's just not. I mean, um, just as I was talking about that that Pong game. The Pong game was one of the earlier big video game cases, because you're dealing with Atari and some other like big, you know, companies at the time. And that game involved the like one of the earlier take home, and I can play it at home versus going to an arcade to play it, like games. And it's like that type of case shouldn't be relevant today, where there's like several thousands of consoles and PCs and portable PCs and all these sorts of things that people can play a video game on. So yeah, it needs to be addressed. I saw Jonathan said, I'm curious about some of your insight into loot boxes and modern game monetization. You know,
Oh,
I I wrote about that in law school. That was my paper. So What I wrote about then, I wrote about, how some people, may usurp the Digital Millennium Copyright Act. That's DEMCA. I'm sure a lot of y'all have had encounters with her at some point if you stream on Twitch or if you try to post stuff on Twitter. But uh, so here's the thing with that. I I have a problem when the game makes it to where you can't adequately play the game unless you purchase this loot box. If it's just for, just like for like looks, like different types of looks, like customized hair or some specialized outfit or something like that, aesthetics, that's the word I was looking for, like aesthetics and stuff like that, then I don't think that it's a problem. I think what ends up happening is you run into a few legal options when it becomes, um, you know, when it becomes I'm going to, some rich kid that's bored somewhere takes their dad's credit card and they just buy up everything that's needed, and then you're not really playing the game. Or, the thing that I specifically wrote about is when people, usurp the game's code with loot boxes. And then they end up cheating, and it costs the experiences of other players, and stuff like that. So I I don't know what's going to happen ultimately with regulating that. I know that one aspect that I talked about was how gambling law. So like there's video game law and there's gaming law, which involves gambling and stuff like that. And so, some of those laws may come into play when it comes to loot boxes and monetization of those. And so, yeah, there's a lot with that, and that's still an evolving topic, so.
Actually, speaking of evolving topics, that is the one question I wanted to make sure I ask you. Is there any like future updates that you've seen like recently in like video games that you think is going to be like a really big like legal topic? Either it is now or it's going to be in the future.
Definitely, the role of artificial intelligence. I mean, that's the big one. That's the one everyone's talking about. Um, you know, will it replace humans? Or how is it being used? What kind of language do we need to put in publishing agreements, that protect, the studio or the developers, right? And, just what type of language do we need to put in, when as it pertains to the copyright of the game, like the code and the illustrations and characters, the audio visual aspects, because as you guys can see, this technology is truly evolving, to the point where, they're creating apps where you can have a full blown conversation, with some AI system, right? So, um, there's a slew of lawsuits, with OpenAI, and I'm sure you guys have probably heard about that. And I think that the video game industry, as well as like the anime and manga industries, are starting to encounter some of these questions and these issues as well. And I don't have an issue with AI generally. I just feel like it could be used as a tool and not necessarily in the ways that some folks are trying to suggest. And so, there still needs to be human oversight. There still needs to be humans involved. And that's just my personal opinion on that. But it could really cause an issue, like I mentioned earlier with the Pal World situation. It could really, cause an issue or questions about, copyright infringement or in some cases, maybe even trademark infringement. But for sure, the copyright aspect has been the biggest issue and concern with OpenAI. And I know that this is going to, you know, continue to become a problem across various industries, you know, as the technology expands and more companies are starting to adopt and use it.
Yeah, I kind of figured you were going to mention like AI is like, yo, this is going to be the next real big piece of litigation.
Mm-hmm. Yeah.
Because it came up a few times in the course of the conversation.
Yeah, and that's because, so I mean, outside of doing, like, I'm a part of the entertainment and IP group. I'm also involved with the artificial intelligence practice group of our firm. We are the first law firm that, you know, actually has a dedicated AI team, and, you know, experts in AI affiliated. So, you know, this is a conversation that our firm is having. You know, in the various practice groups that we have, we are having these conversations because this is, you know, become a forefront issue. And so, you know, it's important. I'm actually going to have a sit down with a few of my clients, and, you know, have a discussion on this. That's going to be either on LinkedIn Live or like Twitter Space or something. We still haven't decided yet, but, you know, it's definitely one of those topics that's just, I feel like a lot of people are afraid of what's going to happen with AI, but also, you know, trying to prepare for, you know, protecting rights and making sure that, you know, everyone's bases are covered.
Yeah, that definitely makes sense. So that's kind of gone through all the questions that I have. I want to definitely. I mean, we were opening up a few questions as we're kind of going through, but I want to make sure that everyone else who had a question, like, we kind of go through all of those as well. But here's one that I took from Tony. Do you help people determine what type of LLC they need?
Yeah. Or just so an LLC is a type of corporation. So I want to make sure I make that clear that is a type of corporation. So I usually tell people to get an LLC. Some people, you know, try to ask if they should just do a partnership, if they should just do a limited partnership or something like that. I usually just tell people to get an LLC. For tax reasons, it's better. Also for liability reasons, you know, it would be better, because again, everything would be against the LLC and not you or anyone else individually. And so, yeah, definitely get the LLC. I also see another question from Tony I want to address, if that's okay.
Really?
He says, do you work with indies and publishers? So right now I am mostly working with just indies. The What I help them with is, you know, with reviewing the publishing agreement. A common thing to your second question, do you see many publishers attempting to get IP rights from developers? I mean, absolutely. You know, that is a common thing. Now, how much and how long, you know, that's something that should be negotiated and should be, you know, mentioned during negotiations. So ideally, you would not want to give a publisher 40% of your IP rights, right? You don't want to give them 50%. You definitely don't want to do 50 or over, right? But some people, you know, may end up signing an agreement, obviously without talking to me or any other attorney, that gives, you know, a lot of rights. And, you know, and I'll give this little gem too. If you see the words in perpetuity in a contract, no, do not sign it. In perpetuity means that they could either own the IP rights or own some other rights or have some other, you know, rights or obligations that are owed to them forever, right? So that's definitely not something that you want. Because even if you're like, okay, I'm done with this person, I don't want to work with them, or this company, I don't want to work with them anymore. Well, they may still be able to, bite off of your game if you have that in perpetuity language, because that means that it's forever until something otherwise happens to the company and it just no longer exists, and there's language in the contract for that. But that's definitely something that I see a lot of. And I've even seen people try to sneak in perpetuity language as to IP rights. Like they have the rights, even if it's like, okay, we have I don't know, 30%, but it's in perpetuity. So they can still get royalties off the copyright or trademark and stuff like that forever. And so you want to make sure that you retain most, if not all, of the IP rights, and that they have a license. Ideally, you would want to just maintain the IP rights and they have a license that, that benefits them. That would be the more ideal situation. But, um, you know, uh, that doesn't always happen. I'm going to be honest. When you're negotiating, these people want to get, as much as they can for helping, and that's fine. But even with that, maybe there could be like a limited language, like, okay, even if you have this percentage, this smaller percentage of IP rights, maybe we can revisit this after so many years, and that sort of thing, and have some sort of reversion language where the rights will revert back to you in the event of something, or at the end of so many years. That would be the more ideal situation. So yeah, definitely important to see what they say as to IP rights, and what they're trying to get out of that, because that's very important.
So I have a question just of something you said. So you mentioned like a percentage of an IP right. What exactly does that mean?
So, okay, when you create a work, like, let's say I created a video game.
Yeah.
I own, and I did it myself. I didn't have no help. I did it myself.
Team of me all by
A
myself.
team of me. And this is just to make the example simplified without going into other complicated stuff. But I'm my own studio. I made a video game, and I think it's going to be very successful. And I so that means I own 100% of the IP in that. I own 100% of the copyright. Like, let's just assume that I'm smart and I got the copyright, I have the trademark, whatever, because it's going to be a series. Like, I at least have the application filed. So I have 100% of the rights because I am the owner, and I can give those rights, or I can just keep it. So what publishers would want to do, or what I've seen, is that they'll say, well, because we see the value in this game, and we think it's going to be good, we definitely want to earn as much as we can, right? And one way to earn as much as they can and also have some form of decision making is to own a percentage of the IP. So if, let's just say that this is a predatory publishing company, they'll say, you know what? I like this game. I want to make some money off of it. I also want to be able to, create certain merch and do certain things and even make money that way. I want 60% of your copyright, right? So that's what I mean by percentage. Like, so that means I'll retain 40% and they'll get 60%, which means that, the, money that's made off of my IP, I get 40% of that. They get 60%.
Okay.
And they'll probably have more, and they'll probably be, it'll most likely be spelled out that they will, have, more of the decision making, since they own majority of the copyright rights, as it pertains to, what type of, or what they want to do with it next, or, that sort of thing. That's also very common, in those games as well, or in those types of agreements, especially as it pertains to um, um, derivative works, like add more, like additional adaptations, or like a prequel, a sequel, or that sort of thing. These are all things that have to be spelled out in the contract, but you also have to consider your IP rights and ownership when you're even thinking ahead in the future. So um Oh, meta. Okay. If you're interested in trademark and patent law, how would you recommend someone begin charting their path in law? Well, you'd have to go to law school. I would probably suggest, shadowing a local attorney if you can find one that practices patent specifically, because that is a beast. I took that class in law school, but it's a very different type of intellectual property, because you're protecting inventions, but they don't care about artistic expression like with copyright. They don't care about the source of it like with trademark. That is about usefulness, inventiveness, and stuff like that. And I'm not a patent attorney, so don't completely quote me on that. But that's what it's about, the process. It's about the machinery, and so you have to have a very particular type of degree to even be a patent attorney. You have to have some sort of particular engineering, or science, and mathematical background. And the patent website, the patent bar website, actually has a list of all of the types of degrees that qualify to take the patent bar, because that's a separate bar from the regular bar exam. Um, that you have to have in order to even qualify to do it. Um, with trademarks, again, you can shout on an attorney for that, but there are even trademark law courses where you can learn it, even after the fact, or you can take it in law school, and that sort of thing. So I say just go for it. Do your research. See which path works for you, but um, that's pretty much what I did. Was I knew I kind of wanted to work in this industry, and so I looked up the types of law that would help me work in this industry, and which ones that I could learn and I could do, and that's pretty much how I ended up here. Um, oh, Tim says, have you or your firm worked with any companies operating under non-traditional business structures, like worker cooperatives in particular? Um, I mean, yes, yes, we have. Not it's not a very common thing. Because I'm just like, worker cooperatives. We haven't had a lot of those, but I mean, honestly, I feel like some of the studios, like, they kind of start out that way, but then it turns into, oh, this is the CEO and founder, and that sort of thing. But not too many that are just purely worker cooperative. Yes. Thank you for posting that patent law link. Yes, that gives all the.
Yeah. Because I just quickly skimmed it while you were talking, and then I saw aeronautical engineering, and I was like, "Wait, I gotta get an engineering degree and a law degree just to take this test, and I might
Just to
fail
take
it."
the patent law,
God,
yeah, yeah. I do not practice patent. Like, I can give people, like how I did earlier. Like, I can just give a very general, overview as to, like, what it is. Um, and that's pretty much what I can. That's the extent that I do. We do, at our firm, we have patent attorneys within our network, that we, if a client needs a patent attorney, then we have patent attorneys in our network that we can, refer folks to. But as for me and myself, I do not do it. And I make sure that that's very known that I can't do it. Yeah, Jonathan, exactly. It's very intricate because you have to be able to speak that language. That's the thing with patents, is you have to be able to understand how these inventions work, or because even with patents, there are pharmaceutical patents or medicinal patents where people have to be able to explain the chemicals and compounds in medicine. And you wouldn't want some random person that's never taken like an organic chemistry class or anything to be able to try to explain that to people. So particularly with video games, you have to understand how all those mechanisms work in order to advise the client and in order to fill the application out properly so that they are protected and their process is protected.
Interesting.
Oh yeah, you also have to make sure you aren't taking someone else's patents. Correct. And you're not going to know that if you don't know the ins and outs of machinery or science and that sort of thing, depending on what side of the patent realm you're on. And so if you're working with inventions, or a certain type of apparatus that involves something in the video game world, and you don't understand how those components work together, like outside of the art stuff, because obviously I know that, but outside of the artistic stuff, if you don't know just how the mechanics and the ins and outs of the machine work, you can't even fully advise and protect your client, and that could be a malpractice suit. So definitely not something to play with.
Yeah, I looked at a few of those and then I was just like, nah, I'm not. I talked to my friend during when they were taking organic chemistry, and I'm like, nah, y'all look stressed.
No, like literally, like that stuff looks not some shit I would do. Yeah, and that's exactly right, Jesse. Ideally, a lawyer wouldn't want to risk their bar placement by making a shot. Yeah, exactly. I mean, that'd be and with intellectual property, just to be quite frank, the malpractice insurance is really high because it's really easy to fuck up someone's, intellectual property rights if you don't know what you're doing. And so, with patents, particularly, honestly, with all of them, you don't want to do something that could cost you, because it's so easy to get in trouble with the bar and possibly lose your job or something like that. And who wants that, especially in this economy? So yeah, definitely not something to play with. Oh, patent troll farms. Honestly, every branch of intellectual property unfortunately has scammers and troll farms. So not surprised to see that. Definitely not surprised to see that.
Just scroll through and see if there is any.
What's your favorite cosplay, Daphne? They always look so dope. Honestly, doing that one I did for DreamCon, when I was Sai Nijima from Persona 5 Royal, that was probably my favorite one because I was able to find a dress and all the accessories that was exactly like her look. And trying to nail a dress that looked like her shadow self was extremely difficult. So, yeah, I was very excited about that.
Ooh, Jesse got all the good questions.
What is your advice for people when they are trying to pick a firm to represent their studio? I mean, the Daphne answer is to hire me. No, but
I was like, do it.
I mean, Honestly, I think that would be my initial response, is to try and communicate with them and get them to hire me. But overall, I would say to make sure that they hire someone who actually knows this industry, who's actually involved with this industry outside of work. Because again, the legal profession can be a little outdated, a little antiquated, and some people will take a case just because rent is due, right? Or just because they're wanting to make revenue, or they're just trying to say like, hey, I've done some work in this particular industry. And so I would say that ideally you don't want to, work in an industry, or I'm sorry, you don't want to be with an attorney who does not, work in the industry, or has not worked in the industry, or isn't actively participating in the industry, because they wouldn't understand a lot of the language. They wouldn't understand a lot of the lingo. They wouldn't understand some of the, the day-to-day issues that, people in the gaming community face. These are things that you want to look for in an attorney, someone that not only practices law, but is a consumer in the industry. Because if they're a consumer, then they understand, how people think, and they can advise you beyond the law. So, some things that I've done is, I've played some of my clients' demos, or, I'll be able to advise them on, just the aesthetics of a game, or, what people that play those types of games are looking for, because I'm in the community. And an attorney that's not, they wouldn't know that. Convince me will probably convince a judge. That's funny. Yeah, honestly, that's how I operate. Is I'm very confident in what I do. I enjoy what I do, and so I know that the passion is what keeps me going. And again, like sometimes, again, I don't even talk to my clients all the time about legal stuff. Like sometimes I'll just ask them, "Hey, where are you guys in the development process? Do y'all need any additional insight? What's going on? Is there anything that I can do outside of the legal realm to help you?" And that's something that I think is very important, when you're looking for an attorney, because so many people, they just practice law, and then they kind of don't do too much else. But it's like I'm actively in this industry. I go to conventions for fun. I go to conferences and things just for the hell of it. And so that's important. Have you had to negotiate potential conflicts amongst clients yet? Not between clients, not between clients. Um, it's just been, um, if anything, it's more so like, maybe someone from their studio left and there was like a little bit of an issue, but between different clients, no. The hyper-connected nature of the entertainment industry means that some things can be really tricky. Like, oh, now I have a suit against a tentpole client of this firm. Yeah, we definitely do. We have a conflicts committee that I'm a part of, so we check for those types of things. And so, if something like that arises, then we're ethically obligated to address it and make sure that we're not breaching any sort of confidentiality, or any other sort of conflict that could cause a problem with our clients. Chase said I'm outside. Yeah. Yeah.
I'm about to just drop the contact because I feel like you just sold all of us.
Oh yeah, no, yeah. Drop the contact. I'm also on Twitter. Big Esquire Bay on there. And I sometimes post different trademark stuff, where I just post whatever's going on, because that's just like, intrusive thoughts area. But I think you have my LinkedIn and everything. My firm Instagram account. I can actually drop that in the chat, because yeah. So that's my I'll drop my socials and stuff.
Yeah, that is definitely like, yeah, I think it's like to make sure I mentioned before the end of every fireside chat.
Yeah, yeah. I still call it Twitter. I don't care what Elon calls it. I'm sorry, y'all. the worst branding situation I've ever freaking heard.
There's just something funny about a lawyer saying, "Nah, it's Twitter." Nah,
yeah, it's Twitter.
Nah,
that's all it's Twitter too. Yeah, it's definitely just gonna be Twitter. Yeah, my personal IG is low key on there, but I mean, I don't know if I mean, I usually just don't post work stuff on there, but I mean, if you wanted to follow me on there, I'll put that as well. My LinkedIn link, I have to grab that, but that's usually where people will hit me up for like work stuff is on LinkedIn. I get a lot of video game clients on there. And I see that I missed this somehow earlier because I've been working like a hog today. That you did tag me in on LinkedIn, Jonathan. I apologize because I did not see that. Yeah, let me share that. I'm gonna just share that, and you guys can.
I got you.
Okay, perfect. There you go. So yeah, I get a lot of clients from LinkedIn. I usually schedule a call and we'll talk through whatever legal issue you have, and then folks will hire after that. But yeah, so that's my information. Oh, and if you just want to email me directly, let me do my email too. Might as well just put that in there. If you want to do that.
Like everyone grab those LinkedIn things, because I feel like at this point we're all sold. We're all going all in law firm.
Well, I'm so glad, and the good thing about it is when you get me, you get the whole firm. So our firm, Holon, we are a full service law firm. We work in various industries. We have connections in various industries. We have a cannabis practice group, and our cannabis practice group is probably the coolest in the country because, we actually have firm branded like rolling papers, which people get a kick out of. So we, we like that stuff. We have a growing, consumer products group. Of course, we have the AI, the entertainment and IP is the one that I'm primarily in. And we have litigation. I mean, we have everything that you need. So if you have any problem, even if it's outside of the direct work that I do, someone at our firm does it. Like literally. Except family law, we're not doing that. But don't come with me with baby mama, baby daddy drama. I used to do that. I don't do that anymore. If it's something that's business related, of any kind, like you got a cease and desist letter from Nintendo because they love sending those, definitely hit me up. Or if you're like, hey, some random person is trying to sue me, and it's a civil matter, definitely let me know. If you, for some reason, started selling hemp beverages or, CBD or whatever, our firm does literally everything and we're connected in every, like, pretty much in every industry at this point. And so, we definitely want to assist. We love working with people that are starting out. We just love making an impact in our community. And that's why I'm aligned with this firm because like we truly care about building a relationship, and we're not chasing dollars, we're chasing relationships, we're chasing connections. And so that's my main thing. Like I didn't, I don't care if anybody signs up with me after this. I love talking about this stuff and just being able to connect with all of you. It's a bonus, if you're like, hey, I want to hire you for something, like that's always great. But the important thing is that I get to share some knowledge that I know and that I'm passionate about, and also getting to meet new people and everything. So I love what I do, man.
Yeah, no, that was a fantastic fireside chat. So I guess to wrap it up, so thank you so much for doing this. This was great. I personally learned a ton, like more than I was expecting to. It sounds like everyone else had a good time as well. Just looking from like the wrapping up comments.
Yeah, don't hire your family to work on your game. That would count as video game law. That would count as video game law.
Does it though? It sounds like you'd be like, I'll take the job, but I wish you didn't put me in this situation.
Yeah. Yeah, no, totally. Totally. Wait, what did Keith say that's wild to? Oh, it was that to the rolling papers? Probably.
I think
But
it was, yeah.
but we do. We we keep I hope that that's wild in a good way. Because it's like one of our favorite things right now. But yeah. But yeah, any like last minute questions before we go, just in case? Want to make sure. If not, you can just email me or hit me up on LinkedIn, honestly. Um, I really appreciate all the love and support in the chat. Thank you guys. Oh, you said non-judgmental. Thank you, Chase. Thank you, Jamal. Thank you, guys.
Yeah.
Tony.
So one last time, thank you very much, Daphne, for your time, and this was a fantastic presentation. And yeah, everyone else, thank you for coming. And I think this is it for today's.
One more thing. Yeah. So I, I, I don't have a studio. I'm VP of Studio Maho, and right now they're doing voice acting auditions. I'll put the name. If you follow my socials, you'll see Studio Maho. But Studio Maho, we have some really cool stuff. If you've played the Persona series, or just watched shows in general, Zeno Robinson, he is our lead. Yeah, he's our lead voice actor. That's my friend. I can see that.
What? No, you just casually dropped at the very end. By the way, I'm the VP. Like, one last thing.
Well, I mentioned your name earlier because I'm also I do the legal work, but I'm also the vice president. So yeah, no, Zeno, he's actually probably going to be another client of mine soon. But Zeno, obviously well-known voice actor, he's going to be a part of it. We have another voice actor that's a part of it as well, but it's a surprise and I can't tell y'all. But just know that it is from a popular anime and folks will freak out, but that's all I can say.
Yep, okay, no, we're not going to ask for spoilers. We'll wait for the surprise.
Yes, wait for the surprise.
So I was like, actually, are there any other companies you're like the VP of before?
No, it's just Studio Maho for now. And that was my best friend Patrick Thomas started it. So I do sit on the e-board for that, and I help them with their legal work, and like with their trademarks and copyrights and contracts. And yeah, we are we are partnering up with another studio. Cutting Edge Animation is a part of Studio Maho as well, and that's with Z. And Z has an amazing animated short series, Captain Zero, and it's big. It's big. He has Keith David as a voice actor for it. Yeah. I just saved all the good stuff for last, but so yeah, I actually worked on the contract that got Keith David, part of the project and everything. So, or I drafted the contract for it. So, definitely check out. I'm gonna type that in here, Captain Zero. Thanks for coming. By the way, drops a bunch of awesome stuff. So definitely look up Captain Zero. And actually I can probably just get the link real fast. Because that's definitely one that you just don't want to miss that. This is Z's Instagram, but it's been all over Twitter and stuff, and it's like that. Yeah, Cutting Edge Animation Home. Yeah, there you go. That's a good website. So yeah. Keith David is one of my favorite voice actors for sure. Yes, he is. I love him. And so I'm excited about that project taking off, and it's going to be at film festivals and everything coming up. So definitely, stay tuned for that because it's getting big. Casually as fuck at that.
Yeah, just like, by the way, I'm working on this big animated series. Also, I'm a VP. Yeah, just.
Yeah, I've been a part of a few cool little things. But
Well,
I just wanted to make sure I got all the legal stuff out, and then save the fun stuff for last, I guess. So
so like, just gonna pause a minute if there's any more just big dramatic drop.
yeah, no, nothing yet until I work with Beyonce or something. No, I'm just kidding. No, nothing.
That next fireside chat. By the way, I'm
Yeah, by
representing
the
Beyonce.
way, by the way, I'm working with. Yeah, that would be the ultimate, fireside chat if that were to happen. But, yeah, I'm working on some cool things. So, really looking forward to seeing how things play out, and I'll probably have some other cool updates for y'all the next time I come around. So. She said it, it's manifested. No, like I will claim that. Y'all can definitely say y'all knew about it first.
Let's go. We knew first. We got the world premieres here.
Yeah. And now my alarm is going off and the dogs are barking, so I apologize for the noises.
Oh no! All right, look, you got to deal with the dogs barking in the background. I think we can actually end it here. Thank you so much for all of the knowledge, all of the exclusive, first peeks. This has been a fantastic fireside chat. Everyone else, thanks for coming and have a good evening.
Thank you guys.